I was sitting at the defense table in a Stamford courtroom when my ex-husband's lawyer said the sentence he'd clearly practiced in a mirror. She's broke. She can't even afford a home or decent food and clothes for the kids. Why should she get them? Kids. We had one child, he said. Kids, anyway. Because a category is easier to throw away than a name. The judge nodded. Slow. The way judges nod when they think they've heard enough. I kept my hands flat on the table so no one could see them shake. I didn't cry. My grandmother raised me on one rule: tell the truth slow, and I was trying to. But none of us knew what was about to walk up that center aisle. Not the judge, not my ex-husband, not his $300 an hour attorney, not even me, because my 7-year-old son was sitting in the gallery with his backpack still on his shoulders. And inside that backpack was a single folded piece of paper that would drain the color out of his paper. Father's face before the hearing ended. Stay with me. You haven't seen what's in that backpack yet. My name is Sarah. I'm 33. For 6 years I worked as a paralegal at a small estate planning firm. 22-minute commute, steady paycheck, a chipped mug on my desk that said world's okayest paralegal. It wasn't glamorous. It was mine. My husband Daniel was the glamorous one. He ran a property company out of a converted barn, a few lakefront rentals, a strip of commercial units on the main road, and a smile that made bankers pick up the phone on Saturday mornings. At a dinner party once, he called my job cute. I let it go. Our son was asleep upstairs. I was tired, and some fights just aren't worth the dishes they break. Our son's name is Eli. He was 6 then, a quiet, watchful kid. His art teacher sent home a note that year. He draws what he sees, not what you'd expect. I pinned it to the fridge next to the grocery list. That was our kitchen. Magnets, lists, crayon drawings, and one woman trying to keep a marriage from tipping over. Then, one October evening, I found a loan agreement in our filing cabinet. $180,000, signed by Daniel, paid to his golf partner. The man had never poured a slab of concrete in his life. I'd spent 6 years filing documents for men who did exactly this. I knew a fake expense when I saw one dressed up in a suit. I asked Daniel about it at dinner. He set down his fork and said, "You don't understand real estate, honey." I signed where he pointed. 6 years of signing where he pointed. I'd told myself that was love. Turns out it was filing. By January, we lived in different zip codes. I rented a small second-floor apartment with radiator heat and a window over the parking lot. Eli said the lot looked like a checkerboard when it rained. I taped a custody schedule to the new fridge and gave him a gold star for every night he brushed his teeth without being asked. But I had no idea how bad it was about to get. In March, Daniel hired the most expensive family law attorney in the county. The kind of firm with a coffee machine that costs more than my car. My boss, the founder of the firm where I worked, offered to represent me for free. I said no 3 times. The 4th time he said, "Sarah, you have a team. Use it." So I said yes. Our first sit-down was in a glass-walled conference room. Daniel's lawyer turned to me with a warm, terrible smile. "Ms. Brennan, just so we get a clear picture, how much do you net per month?" My attorney put a hand on my arm. "We'll provide financials through proper channels." The lawyer nodded, but he didn't need my answer. I'd already seen him glance at a folder on the table. My bank statements were in it. I still don't know how he got them. On the way out, my attorney said one sentence that sat in my stomach for 5 months. "Sarah, they're going to make this about money, not about Eli." He was right. He was always right about the things I didn't want to hear. 2 weeks later, I went to their office for a deposition. The bathroom was down a hallway, past a conference room with the door cracked open, and I heard my ex-husband's voice. Calm, rehearsed. The voice he used practicing golf swings in the backyard. So we open with the financial angle. Then the lawyer. We open with, "She's broke." She can't even afford a home or food and clothes for the kids. Why should she get them? The judge responds to provider language. She hears stable home. She hears father. Will it work? And Daniel said, it's working already. I stood in that hallway long enough to count every scratch on the baseboard. Then I walked back in, sat down, drank water from a paper cup, and let them depose me about my grocery budget. I didn't tell my attorney what I'd heard. Not yet. I told myself it was strategy. The truth was simpler. I was scared. They had a sentence. A single polished sentence designed to make a judge believe that being poor was the same as being unfit. And I couldn't beat it by being louder. I could only beat it by being right. That night I made a decision that would change everything. The motions started arriving like weather. First, an emergency filing claiming my building was unsafe. Photographs of a broken stairwell light. The landlord had fixed that light 2 weeks earlier. They'd photographed it before he did. Someone had walked into my building, climbed my stairs, and turned my home into evidence. Then my own sister testified against me. Under oath, she called me scattered and exhausted and possibly depressed. She told a story about a forgotten allergy medication, except she'd been the one who packed the bag that day. She was telling the truth with all the ownership scrubbed out of it. My attorney watched the video and said, she's not lying. She's selecting. That's worse. Then came the report. A court-appointed evaluator visited my apartment while Eli was away. She wrote 4 pages. Every sentence was technically true, and every sentence was a knife. My 900-square-foot apartment became limited for a growing child. My fridge of basic staples became inadequate. Working from my living room became instability. I sat at my kitchen table at 1 a.m. and read it twice. I looked at the gold stars on the fridge, the crayon calendar, the chipped mug, the drawing of a little son Eli had added to the custody schedule. This is not limited, I thought. This is a whole life. It just doesn't photograph well. No one was coming to save me. The lawyer, the sister, the evaluator, the stepmother, coaching everyone from the second row. They'd built a machine, and the machine had one job, to prove that a number was a mother. I realized then, I had to save myself, quietly, slowly, the way my grandmother taught me, so I stopped reacting and started listening. Eli had mentioned something months earlier, the way kids mention earthquakes, between bites of pasta. He said his dad kept a safe behind a bookshelf that moved. He said there were important papers in it. He'd crawled back there once chasing a trading card and seen it open. He'd also repeated a phrase he heard on one of his father's phone calls. A company name. I searched for it that night and found nothing. No state registration, no website, no filings anywhere. A company that, on paper, didn't exist. Then, one Tuesday morning, a text thread arrived that I was never supposed to see. My sister's husband had added me to a family group chat by accident. Wrong contact. One careless tap. Before I removed myself, I scrolled up. 187 messages. 4 months old. It read like a production schedule. Open with broke. The judge responds to provider language. Just told her I'm worried. She bought it. With a laughing emoji. Once the company dissolves in March, none of this matters. She gets supervised at best. Stay calm in court. She doesn't have the spine for a fight. I did not reply. I did not rage. I screenshotted all 187 messages with the timestamps and the names. Visible, emailed them to my attorney's secure folder and a backup of my own. And then I left the group, as quietly as you close a door on someone sleeping. Because I'd spent 6 years watching people lose by playing evidence too early. Show your cards at the wrong moment and you just hand the other side 3 weeks to build a new story. So I held it. And I hired a forensic accountant. She looked at the public filings, the fake loan, the phantom company, and she said the words carefully, the way accountants do before they have the power to prove it. He's likely keeping the earnings inside the company and paying himself a small salary on paper. based on the rentals alone, conservatively. $2.5 million no disclosure has ever mentioned. Can you confirm it before the hearing? I'd need subpoenas. 8 to 10 weeks. The hearing was in 9 days. So I prepared the case I actually had. Steady job, steady home, steady child. And I trusted that the rest of the truth, the part still folded inside a safe behind a bookshelf, would move at its own speed. They had no idea what was coming. To be fair, neither did I. Here is the part I want to slow all the way down. The morning of the hearing, Eli dressed himself. Maple yellow rain jacket zipped to his chin, even though the forecast said partly cloudy, because he said it made him feel ready. His backpack was on his shoulders. I didn't look inside it. I didn't ask what was in it. You have to understand, I'd had my chance to ask. Days earlier, at bedtime, he'd told me about a paper in that safe. He'd read the top of it. He remembered exactly where it was. And every cell in me wanted to say, bring it to me. I didn't. Because he was 7. If I told him to walk into his father's house and take a document across a custody line because his mother asked him to, he'd carry that for the rest of his life. He'd know I used him. So instead I told him the only thing I knew how to give him. If you ever want to show something to a grown-up who will listen, a teacher, a judge, anyone, you can. You don't need permission. Not your dad's. Not mine. Trust your own judgment. Tell the truth slow. Then I let it go. In the courtroom, his father's lawyer rose for his closing. He buttoned his jacket. He leaned forward so the room would feel his weight. Your Honor, I'll keep this simple. She's broke. She can't even afford a home or decent food and clothes for your son. The standard is the best interest of the child. And the answer, respectfully, is the father. He sat down. Daniel exhaled, that small, satisfied breath you let out when the plane lands and you're in first class. The judge lifted her pen. She leaned forward. She opened her mouth. And somewhere behind me, I heard a bench creak. I heard a small, "Oh," from the elderly woman watching Eli. And then I heard my son's voice, clear, carrying across the room, the way only a child's voice can when it has something real to say. Mom, can I show the judge the letter I found in Dad's safe? The courtroom stopped. I mean that literally. The court reporter's hands froze over the keys. The lawyer's pen stopped against his notepad. The judge's mouth closed around the words she'd been about to say. Daniel turned in his chair slowly, the way you turn toward a sound you recognize but can't place. His face was already changing. The judge looked at Eli for a long moment, carefully, the way she'd studied the case files all morning. Young man, is this something you brought today, on your own? Yes, ma'am, Eli said. Mom doesn't know what's in it. She told me to trust my own judgment. The lawyer shot up. Your Honor, this is highly irregular, counsel, the judge said. A child has offered to share something. I'll determine relevance after I've read it. She looked back at my son. Approach. His sneakers squeaked on the floor. He unzipped the backpack, reached past the colored pencils and a granola bar wrapper, and pulled out one folded sheet of paper. He held it up to her with both hands, the way you hand someone a drawing you're proud of. She unfolded it. She read to the end. She took off her glasses, and she did not look at me, or at my attorney, or at Eli. She looked at Daniel. Counsel, were you aware your client maintains a company holding roughly $2.4 million in unreported earnings, with a dissolution scheduled for next month? The lawyer's mouth opened. Your Honor, I'd need to review. It's a memo from your client's own financial attorney, she said. It describes a plan to shield marital income from division after the divorce. It is dated. It is signed. She turned. Mr. Pierce, does this reflect your current finances? Daniel's tie was still knotted. His suit was still pressed. But his face had gone the color of the courtroom walls. That was a draft, he said. A hypothetical. We were exploring options. It's signed, Mr. Pierce. And then the room went completely silent. The stepmother in the second row stopped blinking. My sister, 3 rows back, stared at her shoes. And my 7-year-old stood by the bench in his yellow jacket, watching his father's face the way children watch weather. No judgment, just observation. I stood. I didn't smile. I looked at the judge and I spoke the way my grandmother taught me. Clear, measured, no decoration. Your Honor, I want the record to reflect that I did not know what my son brought today. I never told him to. I told him only to trust his own judgment about what's true. If the court needs to question that, I welcome it. The judge looked at me, and for the first time all morning, it wasn't procedural. It was one woman looking at another, understanding exactly what it costs to sit still while a room calls you broke. The court hears you, Miss God. Brennan. Then she ordered the document held and authenticated. She ordered a full financial audit. And she said the words, I will hear for the rest of my life. Given the serious questions about the accuracy of Mr. Pierce's sworn disclosures, temporary sole physical custody of the child is awarded to the mother. The father will have supervised visitation only. Daniel didn't move. His hands stayed flat on the table. His was the stillness of paralysis, not discipline. In the hallway afterward, he caught up to us. His tie was loose. He looked 10 years older. He's a child, he said. He didn't know what he did. He brought a paper, Daniel, I said. The truth was already inside it. His jaw worked. I never wanted you broke. Yes, you did, I said. You just didn't want to know that's what you wanted. Eli gave his father a small wave. Fingers only. Daniel's hand went up halfway. Then it stopped. And he stood in that hallway, hand frozen at his chest, watching his son walk away in a yellow jacket. The forensic report came back 6 weeks later. Not 2.4 million. 2.7. There'd been a second shell account no one had found yet. The memo was authenticated. His own attorney's office confirmed the signature under subpoena. The court ordered amended disclosures, recalculated child support, and $84,000 in back payments, based on what Daniel actually earned. Sole custody became permanent. His expensive firm quietly removed his case from the notable wins page on their website. My sister sent me a 1-line apology. I didn't open it, not out of cruelty, but because some apologies are written for the person apologizing, and I was too busy unpacking boxes. That fall, I bought a small 2-bedroom condo. My grandmother's savings, money I'd never told Daniel about, covered the down payment. Eli painted his new room maple yellow, the exact shade of the rain jacket, the exact shade of the morning light in the kitchen, where I taught him to tell the truth slow. Broke doesn't mean unfit. Rich doesn't mean right. My 7-year-old carried a folded paper into a courtroom because for years, I'd told him he didn't need anyone's permission to be honest, not even mine. If someone ever decided you weren't enough because they only counted what they could see, here's though slow enough for both of us. You don't owe anyone the version of you they wrote.